Today, we're delving into a high-profile case that has captured national and international attention, the World Junior Sexual Assault Trial. This case involves several former members of Canada's 2018 World Junior Hockey team accused of participating in a group sexual assault following a Hockey Canada event in London, Ontario. As the legal proceedings unfold, the trial raises critical questions, not only about accountability and culture in elite sports, but also about how the Canadian legal system defines and interprets consent in sexual assault cases. Michael McLeod, Carter Hart, Alex Formanton, Dylan Dubé, and Cal Foote have all pleaded not guilty to sexual assault. McLeod has also pleaded not guilty to an additional charge of being a party to the offense of sexual assault. We're now joined by Kathryn Marshall, a human rights, sexual assault, and harassment lawyer, to discuss what legal principles are being applied in this case, the challenges of prosecuting group sexual assault, and what this trial could mean for the future of consent education and accountability in Canada. Now, before we bring our guests in, given the nature of this conversation, it may be uncomfortable for some viewers. Kathryn, thank you so much for the time today.
Thanks for having me on.
Now, I want to begin with the consent videos that have been played in court for this case. How does Canadian law define consent in the context of sexual activity, and how big of a role did these videos play in the unfolding of this trial?
Well, consent has to be given affirmatively. Consent cannot be coerced. Someone who's intoxicated or unconscious or lacks capacity cannot give consent. And the really important thing in this case is that consent is not a blanket thing that is just given a carte blanche. It has to be given for each incidence of sexual activity. And the videos that have been talked about in this trial, they actually do not indicate or show when consent was given or for what consent was actually given for. And we do know that you cannot give consent after the fact. So the videos themselves are not evidence that the sexual activity that happened in that room that night with the 5 men was in fact consensual.
Now, there's been an uproar as to why Michael McLeod had chosen to take these consent videos in the first place. Is this something that athletes tend to do, or do these videos create more confusion around if there was really consent given?
Well, look, definitely videos of someone saying, I consent, that is not a normal thing. I think we can all agree it's not a normal thing that people do who are engaged in intimacy. And to me, that's indicative of the fact that there were concerns that this was not consensual. And there was evidence that came out today during the trial where the Crown was showing some group chats between the men, some of the men who were charged and some of the other men who were actually in the room, the hotel room that night, where they discussed the videos and they discussed coordinating their stories for the Hockey Canada investigators, and they referenced the consent video. And so clearly to me, that video was obviously taken as some form of a receipt or proof because there were concerns. I actually think the video is a big red flag, and it will not be the smoking gun that the defense seems to think it will be.
And how important is it for consent to be both voluntary and informed under Canadian law? Can you provide examples of where consent may not be valid, even if in these videos that we've seen it's given?
Well, one of the big issues in this case, and something the Crown is saying, is that the complainant was actually intoxicated, that she was totally out of it. These were her own words during her testimony, that she was having like an out-of-body experience, that there were large parts of the night that she couldn't remember. And under Canadian law, if a person is intoxicated, they are not able to give consent. Consent is vitiated. And that's a big part of this trial. The defense have tried to argue that the complainant was not intoxicated, but her evidence is that she was. And if someone is intoxicated or they're not conscious, they can't consent. And look, a lot of these cases they come down to credibility, and they come down to who is going to be believed. And there usually aren't witnesses to sexual assault. It's often between two people where there was no witness. But in this case, there was actually a number of witnesses who are men who have not been charged, but they were in the room that night, and they are starting to give testimony. And we did hear from one of them yesterday who said that he saw the sexual activity that's been alleged in this case take place.
And how much do you think public opinion and media coverage impact the legal process in high profile consent related cases? And do you believe that there's enough legal focus on the fact, or do external pressures sometimes influence the outcome, especially given that these men are professional athletes?
Well, obviously, this trial has a huge amount of public interest. We're also in the middle of the playoffs, so hockey's in the news a lot, and it's gotten a lot of international coverage as well. So people are really following the trial. The trial will actually go on for several more weeks, and I think people are shocked. Like, I've had a lot of messages from people in the media, family, friends, just people in the legal community who are saying, Kathryn, is this normal? Like, and I say, yeah, this is what happens in sexual assault trials. The complainant is under the microscope, and it almost feels like the complainant is the one on trial, not the defendants. But I think this is going to be a really important trial with respect to the question of what is consent, and when can consent be given? When is it not given? What evidence do you need to show consent? And I think a lot of people will be having conversations with their children, their young teens, their young adult children about consent, because this case is all over the place. It's on TikTok, it's on Instagram. You can't turn on anything without seeing the case. The jury has a very difficult job, but they are being sequestered from access to the media. So they're not allowed to read any media coverage on the case. They're not allowed to talk to anyone about the case or what's happening in that jury room. And they're supposed to make their decision based on the evidence that they're hearing and they're seeing.
Well, in regards to what you just said, with the jury not being able to use anything or sway their opinion based on what they're seeing in the media, because this case is covered so heavily, how hard do you think it is for the jury to not be doing that?
Well, I think the juror members understand their obligations and their role, and I'm sure they're abiding by it. As all juries would. That's a huge part of the job. And when the judge was giving her initial instructions to the jury, she did say, like, if you breach these rules for jury members, there could be a mistrial. So the jury would know the responsibility that they have and the consequences of not following those rules. So I'm sure the jury is doing their job honorably. And it's interesting because the defendants actually opted to have a jury trial. So they chose that. They wanted this case heard in front of a jury. And I think that's quite interesting.
Now, in regards to the cross-examination of EM, what is your view on how the lawyers for the accused cross-examined her?
Well, look, no one's disputing that defendants have a right to a vigorous defense. Obviously, they're innocent until proven guilty. But there's been a lot of commentary on just the manner in which the complainant was cross-examined and the questions she was being asked. Of course, we know she was cross-examined for 7 days, which is grueling, and that's a very long time to be under cross-examination. And the reason she was being cross-examined so long is because, of course, all 5 defendants have their own legal teams and their own legal counsel who do the cross-exams. Look, some of the questions that were posed, you have to wonder, what is the relevance of those questions to the material issues in the case? I mean, there's questions about what she was wearing. There was a comment that came up in cross-examination about, would you go home with any tall guy? The Supreme Court of Canada has made it really clear that in sex assault trials, the court is not allowed to rely on myths and stereotypes. But I think we still see those coming through this trial.
And what do you believe are the most effective ways to educate the public, especially young people, about the importance of consent and consequences of failing to understand it properly?
Look, I think it's really hard for young people because I think when you are consuming a lot of the internet, and obviously there's a lot of very easy access to pornography, and very sexualized content on social media that young people are having access to. One of the things, that you see a lot is the idea of consent is never really there in a lot of these videos that are circulating on the internet. And I think It's important for people to understand, especially young people, that consent is something that has to be given affirmatively and needs to be discussed. It should be discussed in advance, and that if someone is intoxicated, they can't consent. That you can't video sexual activity without that person's consent. It's not clear, for example, in this case, that the complainant knew that she was being videoed when that consent video was made. She testified that she has no memory of that video. So I think that just having conversations as to what consent actually is really important. And consent is about communication and it's about respect. And at the end of the day, we have a case here where we have a complainant who, she went home with one man. No, and she's not saying that that was wrong, but she went home with one man. She went back to a hotel with a singular person and somehow ended up in a hotel room where there was up to 10 different men in that room that night. And that is very concerning. And I think the decision will be really important. But there's a lot more witnesses who will be testifying as well. So we'll see what they say.
Kathryn, thank you so much for the time today.
Thank you for having me.